Planning Board meeting of March 10th, 2010. My name is Tim Nelson. I'm chairman of the Planning Board Committee. Call, roll. It looks like all we have missing at this point is Steve, so we do have a quorum. Our first order of business, again this evening, is to resolve a conflict of interest question regarding Mr. Foglio. We do have an attorney here from Jensen, Baird, Gardner, and Henry, and it's Mr. Ken Cole. And Mr. Cody is present at the same time. I guess I will open it up to the board, and I believe there are questions that they want to be directed to Mr. Cole. And I believe, Judy, you had a question regarding conflict or perception, correct?
Yeah. Whose perception?
As I mentioned in the opinion that we sent out, I guess, back in January, the statute basically talks about avoiding any perception of a conflict of interest. And what the statute is talking about there is a perception by the public. In other words, the board should be perceived by the public as even-handed, unbiased, and free of conflict of interest in whatever it's reviewing. So what it's getting at with that particular statute is to do your best, even if you don't have a specific conflict, to still avoid the perception of one. Is that what you wanted, Judy, and more? I'm sorry.
Yeah.
One of the things I also brought along, I don't know if you folks still have it, but you may remember we did a little workshop back in October on board procedures and rules. And in that outline, we recited the 1931 case, which is basically sort of the general law name, even still the general law nearly 80 years later, and what a conflict of interest was. And what the case basically held was that by reason of being that a conflict is by reason of the board member's interest, is the board member placed, quote, in a situation of temptation to serve his own personal interests to the prejudice of interest of those for whom the law authorized and required him to act as a municipal official. So there's always a million gray areas. I mean, we know that always. The statutes only refer to specific conflicts. They refer to ones that are based on financial interests by contract or otherwise, or by certain relation, things of that sort. So again, back in October, one of the things we suggested, one of the things I mentioned in the letter in January was, this comes up in every municipality and often on every board, be it the selectmen or be it planning boards or boards of appeals. The only thing you really can do is what I understood was done here, which is to have the individual disclose whatever that interest is, again, in this, as an abutter, as a relative, as an in-law, as a classmate from a zillion years ago, whatever it may be, and then indicate that from their perspective, the particular individual's perspective, whether they in fact, one, think they should step down, and as I've always said to boards, even boards that have rules that say you can't step down without a vote, that's baloney. If you have a conflict, you step down if you feel you have one. No one can compel you to participate. Or in the event that you feel you don't have one, to request that the board actually vote on that. And the reason for that is simple. If the board votes on it, and it's been put into the public record, to the extent that there's a subsequent appeal, the court gives significant weight to the fact of the disclosure and to the fact of the board's review of it and determination in its own membership as to whether or not there is a conflict. So that's sort of the broad overview of process. Again, you'll never find a specific anything to answer in terms of abutters. I did, in fact, again, just for the sake of it, get into the zoning and planning encyclopedias, just looking for a case recited anywhere. And the only one I could ever find, literally, was one from New Jersey. Big surprise. I was listening to Kramer on the way over. Everybody always picks on New Jersey. What is it? Which basically held in that particular instance that a planning board member had a financial interest because the planning board member owned land that was adjacent to a racetrack that was going to be expanded, and the particular member was in favor the expansion of the racetrack because they were going to benefit from it. That's the only one I could find where it was a direct abutter, and it was, again, years ago in New Jersey. There's nothing in Maine specifically on it at all.
Are there any more questions of Mr. Cole?
I think I'd like to make a statement.
Okay, Doug. Go ahead.
I brought this to the board's attention that I abutted Mr. Cody's land, but not abutted the subdivision.
Doug, you need a mic on?
Nobody listens when I speak anyways. I don't know why I disclosed that I abutted the parcel that Mr. Cody owns, but I do not abut the subdivision. There is a large swamp between us, or Class A wetlands, if you prefer, and it's some 2,000 feet between my licensed gravel pit and this proposed subdivision. 3 times this has come up before the board. All 3 times it has been, the first 2 times it was a unanimous vote that I had no conflict. The last time the chair refused to accept the vote of the board, which was a no vote. A tie vote is a no vote.
Let me just throw into this one. I'm not sure what the motion was. A tie vote on any typical action, for example, before the selectmen, is a no vote. It fails. But if it's a tie vote, and again, I don't know which way the motion was, but if the motion was that the person should participate and they didn't find a conflict, the tie vote does not mean that they have a conflict. Because in that particular instance, it's not an action that you're talking about. It's rather, can the individual participate? So the typical Roberts rule that an action fails doesn't apply because a negative can't say to a person who's been properly, a tie in other words, can't say to a person who's been either properly elected or properly appointed that they lose their ability to participate. It actually requires an affirmative action to tell them they can't participate. And that's just one of those weird exceptions, but if you think about it, it makes common sense. If somebody's either elected or appointed, they're supposed to be able to participate unless they're affirmatively told they can't. So it comes down to how was, if you don't do it that way, it comes down to how was the motion made. If it was a negative motion, it's a tie, but does it come out a positive? And vice versa. So you have to look at it in those particular instances as requiring an actual affirmative majority, one side or the other.
And that didn't happen. So in light of this, I have sought legal counsel. Because I believe at this point, it is my integrity that's in question. I took an oath to do the best I can for the town. Mr. Cody does not like my opinion on what he wishes to do with his subdivision. I'm one of 7 people. So I have 1/7 of the vote. The other 6 can do whatever they want. And I'm represented by Monahan Leahy, who I told him that I didn't think it was necessary that we fight a court battle here tonight. But I have some faith in Tom Leahy, and he reviewed this case, and he does not believe that I have a conflict of interest because I have no personal financial gain, one way or the other. My gain is not financial. I have, in fact, proposed my property to be a subdivision. The conceptual plan is on file here with the town, so I'm not opposed to subdivisions. I felt the board, the previous planning board, erred in not requiring the subdivider to follow the rules of the municipality of the town of Waterboro. In such a way, he should have been required to upgrade the entire length of the road from Townhouse Road to his subdivision according to the town road standards. They did not do that. I believe there should be, for safety issues, a second entrance to this that is open to the public and not just to private individuals. That's my own opinion. And because I stated that opinion publicly, they believe that, he believes I have a conflict. So now it's gone beyond, is this a conflict of interest? And if people recuse themselves on issues that come before the board, we won't ever be able to get anything done here. You're going to have more cases than you got people to serve on this committee. You better have 35 people on the committee, because you're going to have it's going to be like a jury every time you come up here. So I strongly do not believe, and that was the opinion of my counsel. So I don't know where this all goes if this board says that I have a conflict, because I don't believe I have a perception of a conflict, because I have no personal gain.
Well, we start at the beginning, I guess, and part of that is the town's attorney, I haven't said you have a conflict.
No, I understand that. I'm just getting my point.
All I've said is that the board, I've given the board advice as to how it can determine it. It's not my job to make that determination.
If I could, I think it came down to a conversation Judy and I had here last week. And it was, I asked Tim when we had the vote that it wasn't a conflict of interest. I think that it also reads an appearance of a conflict of interest. That's the second part of that. And to me, that's the worse than, conflicts are provable type of thing. Appearance is worse. And Judy and I discussed it because I mentioned, as had Mr. Cody, that a good many people were fully convinced that Doug was doing the right for the town. But, you know, and it's a small town, so you can do that. You know, what's in it for him? So there was appearance, and the argument is the appearance of conflict of interest a personal thing, or is it what you hear from your people in town? And that's where I think we stopped and
Again, the statute simply says that the individual members of the board should avoid the appearance of a conflict of interest, be it the Board of Selectmen, the City Council, or zoning board, or planning board. So how a particular board determines to use that, in other words, is that sufficient to tell somebody that they can't vote, is for that particular board. I can't tell you either way, because the statute doesn't go on in any way to flesh itself out. There hasn't been a case, there's nothing under it. It just says that as a matter of public policy, in determining in passing the conflict of interest statute umpteen years ago in the legislature, they added a final paragraph, and it just said individual members should avoid the appearance of a conflict of interest.
so most of it would be having been solved simply by the fact that we brought it up, addressed it, and voted on it, period.
And that's why we tell people to do that, exactly. To avoid the appearance, put it on the record so that it doesn't end up being, at the corner store, everybody saying, oh, so-and-so participated in that, and did you know he had such and such next door? That's why our advice is that way. The only other point I would make, again, because I'm not taking a position on either side, this is for the board to decide, but I do want you to understand that to the extent that a later court found that there was a conflict, no matter, and I'm not picking this case, any case, the mere fact that the vote may have been 7-0 doesn't matter, the court will reverse the case. If there's a conflict, the mere participation of the individual with the conflict in the decision is sufficient for the court to reverse the case. Because the court's saying it's not his vote, it's also their argument by the fact that they participated as the member of the board up front of the meeting room, which is why we always say if you got a conflict, go sit in the audience, because we don't want you even on sitting at the dais.
So the appearance side of that would be mute, I guess. That'd be,
Right.
That's not a provable one, so it's not going to come back and haunt you.
Right. I mean,
Okay.
exactly.
Okay.
Yep. So
Ken, I guess the question I've got was with appearance. Is the appearance, the uneducated person that's sitting out in town someplace, is it that person that we've got to be considering, or is it, with all the basis of knowledge that you have, it makes sense? You got to vote for the minority, or do you vote for the majority?
that's a very good question. I guess what the courts would typically do is they always, for everything else anyway, they pick this reasonable man standard. So I would imagine on this, they'd pick a reasonable man standard. And they'd say, well, it's the average citizen in town who is well enough informed to know what's going on in the town. And again, it would go back to the fact of the disclosure. And if, based on that disclosure, would that citizen feel comfortable, therefore, that there wasn't a conflict of interest? I think that would be the only way probably to analyze it, because you can't say it's the least, qualified or the most. It's probably the person in between.
Okay.
I got another question. This is a question.
Yep.
So, a situation where a person seems to think that somebody on the board has a perceived or a conflict, that person stays on the board. The board does their job, follows the regulation, appropriately conditions whatever the agenda item is they got before them, and the applicant decides that he doesn't like the outcome. Is the court going to look upon the decision that the board made and go to the ordinance and say, it doesn't matter whether there was a perception or whether there was not a perception, the decision was the correct decision. The board dotted its i's and crossed its t's, and everything was done in the correct manner.
Probably not. I mean, if there was an appeal and it was based, again, on a claim of conflict, what the court would address really is the conflict issue. If it found one, it would send it back. If it didn't find one, then it would look at the specifics underneath it to say, was it done right or not? That's basically what would happen. It would just, but just so everybody understands, it would not, however, say, oh, reverse whatever you might have done and say such and such is appropriate instead. It would send it back, is what the outcome is. If it found a conflict, it'd send it back and say, this person shouldn't have participated, there was a conflict of interest, you've got to hear this without this person and make a determination without that person's input. That would be the typical decision. But even if everything was exactly right, and that's my point earlier, even if the decision was 7-zip and everything was perfect, if the court found a conflict, it would still send it back.
So the appeal would basically, if the appeal went to the courts, it would be an appeal of the conflict, not the appeal.
Well, it would be appeal of...
Depending on what the appeal was.
Because you can appeal a grant as well as a denial. So you can appeal the grant because you don't like certain conditions. There's a famous case out of Gorham on that where Susan Duchesne, who's a big builder, didn't appeal a particular grant and took it all the way up later on and tried to get her in. The courts basically said, hey, you got to appeal one or the other, 30 days. If you don't like the approval, you got to appeal that. It's the same rule. So in either event, you've got the 30 days to appeal, and the court would look at it. You're absolutely right, Tim. You could put the rest of the grounds in there, but the first thing the court would look at would be the conflict.
Okay.
I mean, it could find there was no conflict, and there might have been other grounds asserted, and still reverse it and send it back to you, just so you understand. But it would look at the conflict issue first, because that's, if you look at it, in essence, that's the seminal one, because that's going to send it back immediately without even looking at anything else if that's there. So they'll look at that issue first.
And if they look at that and they find there is a conflict or the perception of a conflict, however they want to look at it, and the board reaffirms their vote without that person participating, then what are they going to appeal it for the next time?
Well, whatever underlying grounds there may have been as well. But again, I would not tell you that a court's going to reverse anything for the appearance of a conflict. The court is only going to reverse something if there's an actual conflict. I mean, they're going to have to find an actual bias, which is in essence what you're talking about when it's not something that's related to a contractual obligation of some kind. Yeah, I mean, that's how they're going to do it. The point on the language in the statute is simply, it's, how to define it. It's a strong suggestion by the legislature, but it's not something that's defined or that says something has to happen, and so therefore it's not directly enforceable by a court. It is enforceable basically by yourselves, and that's the intent of it, to make that suggestion to the board and to its members.
I'm not the expert on Waterboro zoning any longer, so I'm going to ask you, Mr. Cole, should we make a decision that there is, either way, either decision we make, is that decision appealable to our zoning board of appeals, or does it go directly to the court system?
The conflict question would always have to go to the courts.
So it would come out of the town of Waterboro completely, so there wouldn't be another
I
board.
mean, that would be our opinion, because it's not, the zoning board of appeals has a certain, if you look at it in your ordinance, a certain number of things that they can, an appeal can go to them on, basically. And this isn't one of those issues.
I just want to make sure that
Yeah,
doesn't go to that level.
And the courts have basically said unless it's laid out as one of those, then in the general rules, you go to Superior Court.
Are there any further questions of Mr. Cole?
No, I'm happy. I mean, I'm probably the one that asked for, to get it clarified even more. Nope, good.
Go ahead, Frank, I'm sorry. I will ask for a motion at this time. Either way, folks, we have to move on this somehow.
I'll make a motion that Mr. Foglio stays on the board, that there is not a conflict of interest.
I'll second that.
There's been a motion that Mr. Foglio stays on the board without and there is no conflict of interest, correct? All right, and it was seconded by Judy. Is there any further discussion on this motion? All those in favor, please indicate by raising your hand. Those opposed? Those abstaining? 4 in favor, 1 abstaining. So I think we put that conflict question to bed for now. Mr. Foglio will stay on the board as a acting member.
Thank you.
Thank you.
I assume you guys want me for nothing further? I'm here, so...
We got one, being you're here.
Here, okay, that's great.
And
Okay.
We may have another question, so...
well, Mr. Cody's engineer wrote a letter to the code enforcement officer.
Okay,
And this is gonna come up, I'm sure. The code enforcement officer put the zoning ordinance, the subdivision, the zoning ordinance, I guess, on paper, but it leaves a question. And I guess, it's important that we answer that question.
all right. We'll give Mr. Cole a minute to peruse it. I can look on it, Chris.
Actually, I think I'm a secretary.
Yes. I think we need
Yes, I think you're
that
right.
clarified.
Yep.
I'm sure you're going to want it clarified, Frank.
Yep.
I mean,
Yep.
I think the final paragraph is the...
There's the one.
Andy, you know which letter this, what it says? They're referring to, okay.
Well, this goes to another issue altogether, which is that certain code enforcement officers, I'm sure, are aware of, which is that the code enforcement officer in a municipality is the final word, absent an appeal to the zoning board on interpretations of the zoning ordinance. And since Patty's last paragraph says that her interpretation of the above references are to the effect that the proposed road in this phase of Meadowbrook subdivision is not a dead end because it connects to a private road network that connects to Deering Ridge Road, which is a public road, I don't think a waiver is required, because Patty's not saying it's actually a dead end where a waiver would be required. She's saying there's a sufficient connection for, I would assume, public safety purposes, which is probably why it's in the ordinance. And she, as the code officer, gets to make that call, because the case law has said over and over again that as the code enforcement officer, not the planning board, in fact, there's a number of lawsuits over the years that the Maine Supreme Court has decided on that makes determinations as to the meaning of the actual zoning ordinance. So, based on Patty's ruling, I would say that a waiver is not required. If anybody is unhappy with Patty's ruling, again, they can appeal to the zoning board. That's not relevant as before you at the moment, though.
the question is not whether it requires a waiver, because the ordinance says if it connects to a public or private road. The question is, does the planning board have the right or have the authority to stipulate in the approval of the subdivision, what the standards for the road have to be.
Well, the town does that.
What's that?
The town does that, right? We've established town road standards.
Well, no, it says public or private road. And if it's a private road, do we have the right to say what standards it has to be drawn to?
Okay.
You do as to the construction of the road, but not as to, again, the interpretation of whether or not it needed a waiver or something of that sort.
The waiver's not the issue,
All right.
Mr. Cole.
But that doesn't preclude us from requiring a standard from for the road.
No, because in terms of, and again, it's not particular to Waterboro, I've seen this in numerous towns, whether the road is private or public, the planning board can look to the road standards of the municipality and the typical public standards that you would in a subdivision ordinance in reviewing any subdivision. Because what happens 99.9% of the time is that at some point in the future, the residents along that road come visit the selectmen and say how much they'd like to have it at least plowed, if not accepted. And therefore, given public safety purposes of plowing it and getting rescue vehicles down it, you have a right to look at the road width and how it's built and the right-of-way and everything else as to that. And just in terms of the practical aspect of the fact that a lot of people are going to live on it, and how is it going to be cared for thereafter, you have a right to review that as well. And this is very common. Some towns have, again, Gorham's an example just because it's the closest one to you I can think of immediately, have gone the route of actually adopting a private road ordinance, which basically allows some deviation from the typical public subdivision standards for roads, but at the same time requires certain ones typical of concerns with private roads, which is the width of the right-of-way, the grades, the turning radii, to be sure that public safety vehicles can actually get in, because that becomes an issue often. So, no, it's within your authority to determine, I guess one would say, the degree to which the road is built. I guess I would put it that way. But I hasten to add at the bottom, it has to be reasonable based on whatever the development is that's going to go in there. And I can't judge that. I haven't even seen the plan.
Your firm in the past has ruled that, a private road could be constructed to certain standards, and I'm sure if we go back somewheres, we'll find a letter. I can think of a subdivision, but I can't tell you the date, I'd have to look at it. And the developer did not wish to pave this, and it was a private road, and you said that the board could have it as long as it was a private road and built to some standard, that it didn't, we did not have to require it to be paved.
Correct.
If the people wanted it. But I believe, if I remember correctly, there is a clause in the deed, in the sample deed that we get, that stated that the road was built to a certain standard and not to town standards, so that it can't come back on the town.
Well, what we always say in those instances is to put a notation on the face of the subdivision plan that says, one, it's a private road, two, that it's only built to this standard and cannot be accepted by the town as is, and three, that there's going to be a road association, because if you buy in there without a road association on a private road, you're not going to get public financing. So 1, 2, 3 needs to be on the face of that plan in order to, one, protect the town, and two, protect the consumers who'd be buying lots in there.
And we've always, when I was on the board previously, we always required this to be in the sample deed, so that every time the deed changed hands, the new people who may never have gone to look at the actual plan realize that this is the fact of the matter, because people say after they bought it, oh, I didn't realize it was private.
We
It's
always
in-
tell them then to sue their title company.
Right, because it's in the deed.
Yes, because it's in the title, so, yeah, yes.
Okay, so-
I mean, you can do it that way, which is often done. One, I tell you, always put it on the face of the plan, because the plan's going to get recorded, it's public, and whether you looked at it or not, it's one of those things where we call constructive knowledge. If you were dumb enough not to look, it doesn't matter, you're still bound by the fact that that's recorded, just like you're bound by the public laws of the state of Maine. Whether you've read them all or not, too bad, you're bound to know what they say. So you want it on the plan, but you can also condition your approval on there being basically a declaration of restrictions that recites those same things that would go in the deeds if you want to, yeah. And that basically covers everybody. And I will tell you, however, that over the years, I've seen umpteen of these still come to the selectmen of the town council, and still have some activity eventually leading to acceptance of the street. But it's your obligation at least to put everybody on notice. If they can later politically persuade someone to do differently, that's another matter altogether.
Thank you. That was going to come up very shortly. So now we have the answer publicly.
I guess I've still got one just a little bit further, because we hit the subject of road association.
Yep.
And I think that got discussed in this one a few times. And how do you enforce, how do you write that? And the problem is it not the road association for the subdivision, but in this case, we're connecting to a private road that's outside the subdivision. So how do you protect the people in the subdivision in that case?
It depends on the private road, I guess. My easiest example is I grew up in Wyndham. My family, a lot of them still live there. Wyndham has 85 miles of private roads because of all the roads that went down to the lakes.
Yeah.
There are road associations, but most of them are completely voluntary because most of those roads have been there 150 years.
Yep.
There's no way to make anybody contribute because when they were laid out, no one ever thought of the fact that there should be contributions made. I mean, they were just camp roads. If the road that this road connects to has an existing association, then you can try to deal with that. If they don't, then you're that private road has basically become a public right-of-way is what it happens, because it's been there for more than 20 years, probably. The world's been crossing it, probably. It may not be 150 years, but it's been used to such an extent that it becomes a public right-of-way. And all you can do in terms of how well it's maintained or not is you have to hope that the people in this new subdivision will work with the people along that road to take care of it. But it's not, because it's not an actual public road in the sense that it's a town road, there's not much else you can do. If there was an existing association, if this was connecting to an association road, which you see sometimes when you get multiple phases, then you can make this association work with that association to actually take care of the overall sort of network.
The developer actually owns this road.
Yeah.
It's his property. It's
Well-
not parcel of his property.
Well, then, to the extent he owns that, you can actually, you can actually condition that further development of this will be, any further development of this parcel, I would tell you on this plan, will require that those additional house lots, or whatever they are, contribute to the overall upkeep of this road. And that doesn't harm the developer at this point, but it allows him to go forward at a later point and make sure that at a later point, if you've got 3 more subdivisions in there, that they're all working together to take care of that road. Otherwise, you do end up with the usual problem with a lot of these camp roads, which 30 or 40% contribute, the other people pay nothing, and the road goes to hell. And then it is a public safety concern for the selectmen and for your public safety department. I mean, how do you get people down in there if the road gets beat up and no one's caring for it?
Although road associations is the main law nowadays. I was impressed reading some of that stuff. I mean,
Yeah,
they
there's
really, if you're done right, they're very effective.
And there's a very nasty statute that allows, if they're not done right, you to compel a meeting, make everybody come together and have to form one. It's a good way of making your neighbors never speak to you, into the future ever again, but it can be done.
In this particular case, this is, Mr. Cody owns a lot of land. We asked him for a master idea of what he was going to do with the rest of this land. He doesn't wish to come forward with that. That makes this a little bit more difficult because because then you say exactly what standard do we want. If we knew he was going to continue with some more subdivisions in the future, then you could say, well, that'll take care of itself as the subdivisions are developed. But being they're not, it puts a burden on us to make sure that this road will handle. What we've got is a road that was built for 20 houses. It's going to have 63 houses on it when it's done, with one way in and one way out, you know? And the previous board never required, we've got a funnel, we've got a wide road going to a narrow road.
I think we're getting into
Well, I think
beyond
we
that.
got
It's
all issues.
within, all I can say is it's within your discretion, and there are ways to do it in the best way, I think Tim already knows, which is condition whatever you do so that it's there for the future, so that the next time something comes back, that board knows, you basically telegraphed it, be it 2 years or 10 years from now, that this is something that needs to be addressed.
Okay?
Thank you, Mr.
Thank you.
Cole. Are you ready to go forward, Mr. Cody?
Yeah, I'm gonna go forward, but I'm not gonna go forward tonight. I guess I'm gonna be back on the list. Because Joe Thompson couldn't make it tonight.
Okay.
I'll let you put on the next agenda.
Okay. And that will be, we've already
This is the 17th.
canceled the 17th.
Yeah, this is the 17th.
This is the 17th meeting, so it would be the first meeting of next month.
April 7th.
If you say.
Yeah.
April 7th.
Thank you for putting the calendar back up.
All right, since Mr. Cody's asked to be tabled until the April 7th meeting, I'll go on with the further agenda meetings we have. Minutes of previous meetings, do we have anything? Nothing. Nothing for reports from officers. Any old business anybody would like to discuss at this point? Communications are none.
Do you have one? Oh, I thought you had old business.
No?
Oh,
No.
my
No.
peripheral vision stinks, okay.
Any new business? None. And last but not least, a motion to adjourn.
So moved.
Second? All in favor?